day, everyone. I'm Metuge. It is an honor to be presenting to you all today, albeit not in person. I will be providing a brief overview of the regulatory framework for MSP in South Africa. My presentation will include the legal framework for the attainment of sustainable outcomes in the development of marine area plans, as well as provisions for participation by all stakeholders in the MSP process. I will begin from the constitutional framework for environmental protections in South Africa. This is quite significant because the Constitution makes environmental protections a human right when it entrenches everyone's right to an environment that is not harmful to their health or well-being, amongst other provisions that fall in Section 24 of the Constitution.
So just to check everyone is listening well, sorry for disturbing. Okay, we continue then.
Worthy of note with regard to the environmental protection and right in Section 24 of the Constitution is that it places an obligation on the state to achieve the protection of the environmental rights through reasonable legislative and other measures that secure ecologically sustainable development and use of natural resources. Significantly, the Constitution also requires that the various sector departments in their contributions for the development of reasonable measures for the protection of environmental rights. These sector departments have a constitutional obligation to cooperate with each other. It goes without saying, the sector departments do have a common interest as far as marine spatial plan is concerned.
I'm sorry for interrupting this again. Some people are complaining that you're saying that it can't listen well. The volume is indeed very low in the recording, and I have to play it over the microphone, so it might be very low. You might need to turn up as much as you can in volume, but I'm not sure this will make it. We tried different ways of presenting or sharing before, but it not work. So we continue, okay? I didn't want to interrupt the presentation, so we continue a bit longer. But I'm sorry, the volume is at the highest here.
Yes, I think so, a little.
Oh. Section 24 of the Constitution has led to the development of a number of environmental. Section 24 of the Constitution has led to the development of a number of environmental instruments in South Africa, the most noteworthy of which is the National Environmental Management Act. Significantly, NEMA establishes principles for decision-making on matters affecting the environment. In accordance or in terms of its principles laid out in Section 2, environmental development must be socially, environmentally, and economically sustainable. NEMA is the framework environmental legislation in South Africa. It is supplemented by specific environmental management acts, which include the Integrated Coastal Management Act, the Biodiversity Act, just to name a few. Worthy of note is all the SEMAs must be read in a manner consistent with the provisions of the most important importantly, they must be read in accordance with the principle of sustainable development contained in Section 2 of the Sustainable development is a term frequently employed within the context of environmental law. However, there is no generally accepted definition of the term. Reference in this case is provided to the decision of the International Court of Justice, which has said sustainable development is not about advancing certain interests, but establishing a balance between environment, social, and economic considerations. In South African law, the domestic courts may, when interpreting a right contained in the Constitution, refer to public law.
Hi everyone, I'm sorry for interrupting the presentation. It's actually a very interesting presentation, but we are having problems with the sound. I see some people saying that it's getting better now. Unfortunately, the uses the loudest and the best microphone to get the presentation to. So we should just perhaps make a decision here. It's a very interesting presentation. And I think we benefit a lot, but if we cannot, either we just follow the slides, reading them.
Yes, and Lisa has offered to email everyone the presentation so they can have it and watch it in their own time.
Okay.
I see that a lot of people are now saying that if they plug in their headphones, they can hear fine. I'm not having a problem either. People are saying it's okay, so let's carry on, I think, if it's okay. Is now, and we will send the recording as well.
Okay, so luckily this, the presentation has text in the slides, so if the sound is very bad, let's try to read the slides when we have time, and that will be the only problem. So, yeah, let's enjoy it.
Thank you, Andre.
Amongst other things, MSP regulates the decision-making processes for the issue of environmental authorization. An emphasis therein in the decision-making process, the attainment of sustainability, implies that the concept of sustainability is process-based and not determined by the outcome itself. A primary compulsory tool employed by MSP for the attainment of sustainable outcomes is the performance of environmental impact assessments. As a matter of fact, MSP provides for the publication of lists of activities that may not commence without an environmental authorization. And a prerequisite to the obtention of any environmental authorization in terms of MSP is the conduct of an environmental impact assessment. As far as MSP is concerned, the relevant domestic law is the Marine Special Planning Act 16 of 2018. This act is not yet in force. However, it is significant because at the time when it does come into operation, it will prevail over any national law as far as marine special planning is concerned. The MSPA provides for a 6-step MSP system in South Africa, which includes the firstly, development of the marine special planning framework, then the development of the knowledge and information system, development of marine area plans, effective implementation, monitoring, and evaluation, as well as the review of marine area plans. As earlier mentioned, The development of the Marine Spatial Planning Framework constitutes the first phase of the iterative process of the Marine Spatial Planning System in South Africa. In 2017, the Department of Environment, Forestry and Fisheries published the National MSP Framework sets out the goals.
There's a microphone on, please. No. Kelly.
Framework sets out the goals, objective principles, and framework for the development of marine area plans in South Africa. It has identified 4 high-level goals, amongst which include sustainable development and contributing to good ocean governance in South Africa. In terms of the MSPA, the principle of sustainable use of the marine environment and its resources should be applied and considered with due regard to the precautionary approach. What this entails is it seeks to promote economic development that is socially and environmentally sound, while ensuring that spatial consideration is provided to ensuring long-term provision of ocean services, which are required for sustainable economic growth. There is no specific mention of a tool that must be employed to ensure sustainable outcomes within the Marine Spatial Planning Act. However, turning to the Marine Spatial Planning Framework, there is a provision for an initial assessment of priorities for each marine area, taking into account environmental pressures, human uses, and development opportunities. In terms of the MSPA, the principle of sustainable use, with regard to the precautionary approach, the Marine Spatial Planning Framework echoes Article 15 of the 1992 Regulation. The substratum of the precautionary approach is that where there is a lack of scientific certainty about the impact of proposed activity or development on the environment, caution must be exercised and where necessary measures taken to protect the environment. This is clearly stated in South African law, and the requirement is where uncertainty exists, the applicant for an environmental authorization or permit is required to conduct an environmental impact assessment before the issue of the relevant authorization and prior to the commencement of the activity that is subject to an environmental application. The conduct of environmental impact assessment is quite important in the Marine Spatial Planning process. The Marine Spatial Planning Act itself doesn't prescribe for the conduct of environmental impact assessment. However, because the activities that would be performed in the marine space involve various sector departments, it is incumbent on the various sectors to ensure that all persons applying for environmental authorization do conduct an EIA. In turn, the reports from these environmental impact assessments will feed into the knowledge and information system that has been established by the Marine Spatial Planning Act. comes information from all sector departments and would feed into the preparation of marine area plans. As mentioned earlier, one of the goals of marine spatial planning in South Africa is the attainment of good ocean regulation. What it entails is that there has to be collaboration between organs of state such as the Departments of Environment, Forest and Fisheries and the Department of Mineral Resources and Energy in the National Working Group that is established in terms of Section 9 of the Marine Spatial Planning Act. Moreover, not only should they collaborate with one another, but their decision making must be underpinned by sound knowledge and adaptive management. To this end, all sector departments have an obligation to provide the chair of National Working Group with relevant sector information that will contribute to the work of the National Working Group in developing marine area plans. Furthermore, the Marine Spatial Planning Act makes specific provisions for consultation in the development of marine area plans. In terms of Section 8, the National Working Group has an obligation to ensure that all stakeholders are adequately consulted. This consultative process must include the general public as well. In addition to the consultation requirements imposed on the National Working Group, sector departments also have the same obligation, irrespective of the consultative process undertaken by the National Working Group, to consult their respective stakeholders and to ensure that the outcome of their consultations are made available to the National Working Group prior to the development of any marine area plan. Beyond the provision that the National Working Group must ensure that stakeholders are adequately consulted, the Marine Spatial Planning Act doesn't define what these actually mean. It only provides a little bit further that the Minister of Environmental Affairs would have the responsibility to make regulations to determine the manner and form of consultations contemplated in Section 8. At this point, the assumption can only be that at the time when the Marine Spatial Planning Act comes into force, the minister will have to rely on the decisions of the courts to determine what would amount to adequate consultation for the purpose of establishing marine area plans. Leaning on decisions that are available at the moment, it is clear that the requirement for public participation goes beyond its inclusion in instruments, in regulatory instruments. The state has an obligation to see to it that the right to public participation is actually exercised. Nevertheless, the decisions of course do not actually dictate what method the state departments must employ to ensure that public participation is effective. There is no method that is set in stone at the moment, and the courts do acknowledge that public involvement can be complied with by employing a variety of methods. Leaning on decisions that are, it is also held that public participation may entail affording the public and all stakeholders an opportunity to provide submissions or feedback representations with regard to draft domestic instruments that impinge on marine spatial planning or otherwise environmental development. As a matter of fact, it is the practice in South Africa that before a legal instrument comes into force, the draft of that instrument is published, and the public and relevant stakeholders are afforded at least 30 days to provide submissions on the draft so that their input is taken into account before any instruments come into force. What is clear at this stage is that public participation needs to be realized as a matter of fact. It is at this point, I would like to conclude by stating that the concepts of sustainability and participation are entrenched in South African law. These principles are, as a matter of fact, incorporated into the marine special planning processes by the Marine Special Planning Act. Nevertheless, this framework legislation for marine special planning is not yet in force. However, at the time when it does come into operation, it will prevail over all other domestic legislation as far as marine special planning is concerned. So there is indeed a need for future research in the marine special planning regulations to ensure that at the time when the Marine Special Planning Act does come into operation, there are no existing conflicts between its provisions or marine area plans that will be established in terms thereof, and the requirements for licenses, authorizations, permits that are issued in terms of other domestic law, including the specific environmental management. At this point, I would like to conclude by
Thank you, Andre, for sharing your screen, and thank you all for the patience with the technical issues. I hope all of you hear most of the presentation without much disturbance.